All rise. Feu vous levez. Please be seated.
Please proceed, Mr. Mladić.
Thank you, Your Honors. I have two corrections to the transcript that are the result of my mistakes. At temporary transcript, page 21, line 20, what has been recorded as P3528 should in fact be P3258. And again, that was because I misspoke the number. And also on temporary transcript, page 40, line 15, I misspoke as to P2201, where I said paragraphs 4 through 9 and 11. I meant to say paragraphs 4.9 through 4.11. And now I will resume. Lastly, the limited access to reliable communications and the inability to receive correct, real-time combat-related information negatively affected the general's ability to effectively command and control subordinates. Whilst the VRS employed a comprehensive reporting system, including daily combat reports, these reports were compiled and given to the Supreme Command. And unless the general actively inquired about them, he was not made aware of them. Witness Trukulja, transcript page 35069 through 35072. Witness Banduka, transcript page 27310. There were instances where VRS subordinates would act outside their orders without the general's knowledge. This severely compromised his ability to effectively command and control the VRS forces. Prosecution witness RM511 recalled serious problems with officers undertaking actions at their own will. Transcript page 506829. In evidence, we even have one incident that involved an officer who, without his commander's consent or knowledge, led a group with the intention of capturing Moimilo. This group suffered serious losses, and the commanding officer, and the officer's move was described in the evidence as reckless and not the behavior of a properly trained soldier. And we have that in transcript page 5068 through 5069. The record also revealed why the accused had good reason to consider reports of internationals and international media unreliable. First, he considered the internationals biased against the Serbs. For example, I refer the chamber to paragraphs 1728 to 1733 of the defense final brief for UNPROFOR bias in Sarajevo, such as selective investigations and heavy reliance upon ABIH data and personnel, as evidenced by the testimony of several prosecution and defense witnesses, such as Mole, Frazier, Thomas, and Moroz. Second, the accused was aware of all the disinformation spread by the ABIH, discussed at paragraphs 2507 through 2512 of the defense final brief. These include BIH government and their frequent exaggerations of the situation to provoke an international response. D1298, paragraph 19. Third, we saw numerous examples of the international media misrepresenting incidents to the ABIH side's advantage, discussed at paragraphs 2515 to 2517. In Srebrenica, UNPROFOR was well aware of weapon supplies to the ABIH through, for example, Tuzla Airport, which was under UN control. It was a continuing effort to move weapons into Srebrenica and Žepa in order to keep the 28th Division supplied. Expert of the prosecution Butler at transcript page 16706 to 16707. For instance, a Turkish C-130 aircraft escorted by U.S. F-16s landed at Tuzla while the radars were turned off. D1240, paragraph 13. This aircraft supplied the Bosnian Muslims with weapons. Witness GRM 037, transcript page 39017 through 8. However, no action was taken to prevent the Bosnian Muslim violation of the UN Security Council resolutions prohibiting the import of weapons and military equipment. In contrast, force or actions against the VRS were just a question of, quote, waiting for an event to occur, end quote. That was General Rupert Smith, transcript page 7417 through 7419. Although Srebrenica was meant to be a safe haven, UNPROFOR did not demilitarize Srebrenica in 1993 through 1995, following the demilitarization agreements. Similarly, Dutch BAT failed to disarm the 28th Division. P23. Witness Van Duyn, transcript page 10334 through 10336. Witness Franken, transcript page 10751 through 10752. Although the UN set up a weapons collection point in Srebrenica, Bosnian Muslims only surrendered old and non-functioning weaponry. D270, page 5. Prosecution expert Butler at 16793 of the transcript. And Egbers testified that these were weapons which were of no interest to the Bosnian Muslim side, 13400 to 401. Again, no reaction of the UN. Smuggling goods through humanitarian convoys was also a common method used in Srebrenica, Žepa, and Gorazde, D1615, and the testimony of GRM 037 at 39018 of the transcript. Multiple UN officials even acknowledged that these convoys were used to supply the ABIH. Transcript page 7528, General Smith. Transcript page 10673 through 10674, General Nikolai as to Sarajevo. But they never undertook action to prevent it. Similarly, the UN was well aware of the black market in Srebrenica as Colonel Boring told us about at transcript page 10,038. If we could have the next slide. In addition, multiple witnesses have talked about UN bias and weapon smuggling occurring in Gorazde and Bihać. For example, in Gorazde, GRM 097 was shocked to see Bosnian Muslim soldiers descending from an UNMO vehicle, transcript page 40089. And as former UN officer Jan Segers testified, around Bihać, even UN personnel were involved in smuggling for the ABIH side. Segers also stated that helicopters were being used to smuggle ammunition cases during the time of the embargo. D1465, page 4, D1466, page 3. A 29 May 1993 message from the Zagreb Embassy of BIH, which we have up on our screen at the moment, and in evidence that is D362, confirms that extensive military weapon supplies were sent from Croatia to Bihać.
I'm not sure that we have the right.
I think we need
slide
the
on the
prior
screen.
prior slide on that one. Oops. Yeah. Now, General Mladić constantly complained about smuggling practices and the UN's role in this regard. D142, pages 1 through 2, P785, paragraph 57, evidence that. However, nothing was done with these legitimate complaints. Does all this evidence demonstrate that the UN was impartial and treating Serbs the same as the ABIH? No, it's open to another interpretation. Now, if we can have the next slide. The record also revealed why the accused had good reason to consider the international media unreliable. At the time, subordinates informed the accused that media reports were not objective. For example, at P3877, page 2, or that media reports were fabricated. And we have now on the screen P3951, page 3, which talks about that. The main staff also believed that the media reports were unreliable. At page 45 of P338, the 1992 VRS Combat Readiness Report, we see the quotation, quote, "The orchestrated planting of lies about alleged massacres," and then we see, "and other media fabrications served to project a distorted picture," end quote. BBC journalist Martin Bell substantiates the legitimacy of this belief held by the VRS when he testified at transcript page 7865 and 6 that international journalists employed the mindset of the Muslims being the good guys and the Serbs the bad guys. At transcript page 7868, Bell noted that, quote, "It was not so much a case of consciously taking sides as of not going anywhere outside the government-held parts of Sarajevo and seeing the war from that perspective, end quote. If we could have the next slide. This is significant because it is not enough for the prosecution to simply prove that an accused received notice of crimes. I remind your honors of the Mladić case, volume 3 of that judgment, paragraphs 99 through 100. As in this case, in that case, President Mladić received reports from internationals and subordinates and the media. And the chamber found that he was put on notice about crimes. That was at paragraph 270 of that judgment. However, this was deemed still insufficient at paragraph 276 of the judgment to satisfy the mental element for two reasons. First, the chamber considered whether Mladić believed the information to be reliable and concluded that he did not. The chamber stated that the information from the Serbian sources either made no mention of crimes, or when it did, the allegations were reported as propaganda by the international community. Second, Mladić believed that the relevant authorities were responding to the allegations. That's at paragraph 141 of volume 3 of the Mladić judgment. In the present case, although there were problems with the justice system, the accused reasonably expected the proper authorities would respond to offenses. We saw that he delegated the responsibilities for initiating arrests and investigations to his subordinates, P3066, P244, paragraph 32, and the testimony of General Milovanovic at page 16953 through 4 of the transcript. And commanders were expected to be aware of their responsibilities in disciplining their troops. There was a procedure for serious criminal offenses, P244, paragraph 33, next slide. Furthermore, the accused himself repeatedly prohibited the commission of crimes. We have examples at P474, page 5, that's directive number 1, D187, D1949, P1094, and P3673, page 6. And the chamber has seen examples of subordinates reporting crimes up the chain of command and stating that they had or were responding to them. For instance, I refer the chamber to P2843, page 2, that says an investigation is underway, a special report to follow, end quote, and P3818, which we now have before us, that says, quote, reprisals by soldiers on leave from the front, but forceful action by the military police of the 1st KRK put an end to such behavior, end quote. I note here that this report also makes clear that these crimes were neither ordered nor were they VRS policy. Thus again, we see reasonable doubt. Knowledge of crimes in itself is insufficient also because in many instances, those crimes were committed by people over whom the accused had no authority. The prosecution submits that Mladić, quote, knew of crimes committed by Serb forces, end quote. And we saw last week, according to them, Serb forces includes civilian police, paramilitaries, and even local villagers. In such cases, as even prosecution expert Tonins testified, the most that the VRS could do was report such crimes to the organs in charge of those units. That was at transcript page 20624 through 5. And in fact, we did see the accused repeatedly went to the relevant authorities. Taking paramilitaries as an example, we saw the accused's letters to President Karadzic at P3095 and D1503 as to Sanski Most. Finally, on the subject of knowledge, the evidence cited by the prosecution should be carefully examined, as they do not prove that the accused knew of VRS crimes. For example, it cannot be concluded from the accused being informed of deaths that he had reason to believe that those deaths were criminal and not unfortunate, but lawful collateral damage, or lawful deaths of combatants. The accused, having met with someone that he had a legitimate duty to meet with, does not prove that that person informed the accused of any crimes that he had just committed or was about to commit. Destruction of non-Serb civilian areas does not prove that crimes occurred when they could also have been legitimate military objectives. Evidence that a subordinate knew about a crime does not prove the accused was actually informed. Reports of crimes that do not say who was responsible, and in some cases which clearly identify someone other than the VRS, do not prove knowledge. For example, I refer the chamber to P3951, where at page 3 it reports that the civilian police committed a massacre. Just as the general was not aware of the actions of his subordinates taken outside of the VRS chain of command, he was also not responsible for the criminal actions of outside organizations, as they were separate from the VRS. For example, crisis staffs, if you can have the next slide. Crisis staffs were not criminal organs. As prosecution expert witness Dorothea Hansen stated, they existed under Yugoslavian law, P379, paragraph 11 through 12. Also, witness Mladić confirmed that at transcript page 28378, and we also see it from D732, paragraph 8. And crisis staff were also used by the Muslims and Croats, P379, page 5, footnote 5. Crisis staff were intended to take over the lawful duties of running a municipality when the normal organs were unable to function during wartime. D492, paragraph 5, for instance. The chamber saw evidence of how they carried out regular governmental functions, such as maintaining utilities, obtaining food and supplies for residents, and ensuring running of schools. P413, page 6 through 8. D827, page 15, 87 through 88 and 91. P3913, page 6. P2414, P3172, paragraphs 2 and 7 through 9.
Mr. Mladić, can we just look at page 50, line 17? Did you say page 1587 through 88, or did you say page 1587 through 88?
15, comma, and I probably did not pause enough, and then 87 through 88.
Thank you.
At paragraphs 447 through 460 of the defense final trial brief, we see how crisis staff showed concern for all citizens, regardless of ethnicity. As part of their functions, Dr. Hansen acknowledged that crisis staff were permitted by Yugoslavian law to undertake defense obligations. P. 379, paragraph 14. This included replenishing the war units, which Hansen agreed was a pre-existing obligation and, quote, not controversial, end quote. That was at transcript page 4206 through 4207. So military and crisis staff interaction is not criminal. The prosecution has failed to establish a link between the crisis staffs and the accused. General Mladić had absolutely no role in their creation. He wasn't even there. From the beginning, crisis staffs were not to include military personnel as members, P. 408. At paragraphs 478 to 492 of the defense brief, we review the evidence demonstrating that the VRS and crisis staff had completely separate chains of command. There, we also discussed the existence of armed units created and commanded by crisis staffs, and for whose conduct, therefore, the accused had no responsibility. The prosecution concedes at paragraph 597 of their final brief, quote, no VRS witness testified that he had followed an order issued outside of his chain of command, and no crisis staff member testified that he had issued an order to a VRS unit, end quote. At paragraphs 493 to 498 of the defense brief, we also cite evidence proving that VRS members were not part of crisis staff decision-making, nor were they members. Witnesses Davidovic, Javoric, Basara, Ajic are just some of the evidence as to that. When VRS personnel were present at crisis staff meetings, their role was only to report on military matters and not to vote on decisions. We heard that from Colonel Basara at transcript page 34388. There were fundamental disagreements between the VRS and crisis staffs throughout the conflict, including repeated problems relating to crisis staffs' attempted interference with the armed forces. At one point, certain ARC authorities sought the removal of the accused as commander of the main staff. D. 839, page 5. These clashes are discussed at paragraphs 502 to 508. These clashes are evidence of reasonable doubt under the evidence and mandate acquittal. If we can go to the next slide. On the issue of disarmament in the municipalities, the evidence shows that contrary to the allegations, there was no criminal plan for crisis staffs to disarm non-Serbs so that the VRS could then attack the unarmed non-Serb civilians. First, in many cases, the VRS had not yet been formed when the takeovers were completed. Second, the crisis staffs, as municipal governments, were not only within their legal authority to disarm civilians, but had a duty to maintain order. The instructions applied to all ethnicities. I refer the court to D81, Conclusions of the ARC Crisis Staff, 18 May 1992, on your screens as we speak. Another separate organization was the Serbian Police Force, the RS-MUP. The RS-MUP formed part of what is described as a broader criminal narrative in the prosecution case surrounding the establishment of, quote, parallel civilian and military structures, end quote, as a mechanism for ethnic cleansing rather than legitimate government. That's repeated at transcript page 44440 and in the prosecution pretrial brief, paragraph 34. In reality, the RS-MUP functioned as a vital public institution, ensuring order in the face of armed and aggressive Bosnian Muslim forces set on waging war against Bosnian Serbs. The RS-MUP was a civilian organization with an organized command structure answerable to civilian government structures. We have that discussed in our final brief at paragraphs 533 through 547. Any criminal act perpetrated by RS-MUP officers was the responsibility of the Minister of Interior, who commanded the RS-MUP units. And in that case, that was Mr. Micho Stanisic. But the purported notebooks used by the prosecution document Mladic's efforts to further law enforcement and compliance with the law. For example, in one of its citations, the prosecution uses to support Mladic's cooperation with Micho Stanisic at paragraph 511 of their brief. The following statements are found, and we're talking about P358. Quote, to uncover the crimes and murders that occurred, end quote. And then also, quote, who allows armed gangs from Serbia to come to the RS, end quote. That's at page 362. Another quote is, quote, the law on military courts needs to be adopted, end quote, page 363. And quote, investigate all abuses and punish them in the most efficient way, end quote, page 365. Without the shroud of a joint criminal enterprise, these meetings are just the normal discussions between organs of a government system engaged in a conflict. The evidence lacks the ability to link the accused to the alleged crimes and is not the only reasonable interpretation. And thus, pursuant to paragraph 93 of the Gotovina appeals judgment, acquittal is appropriate. The prosecution argues that the accused exercised de jure and de facto control over RS-MUP, who were at times resubordinated to the VRS. This is at paragraph 530 of their final brief. Resubordination only occurred on an ad hoc basis, and even when resubordinated, the RS-MUP remained within the rigid RS-MUP chain of command, as attested to by the prosecution's own insider witness, Momir Nikolic, who testified at transcript page 12093, quote, what I know for a fact is that they always had command and control over their own units when they would be carrying out joint tasks with the Army, end quote. Colonel Kevats also provided that when joint operations were held, quote, they, VRS and RSMOOP, operated as two distinct units, each carrying out their own assignments, whilst helping the other to carry out their assignment. There is no suggestion that one unit had command authority over the other, end quote. That was at transcript page 30544 through 30545. The prosecution's own evidence indicated that resubordinated MOOP, quote, shall be under the direct command of certain ministry officials, end quote, P 3855. We heard evidence of coordinated action, or in BCS, sadejstva, between RSMOOP and VRS, which is not resubordination. While the prosecution would like you to believe that the RSMOOP assisted in implementing the common criminal purpose by placing personnel at the VRS's disposal, the prosecution then decides it doesn't even matter if the RSMOOP are formally resubordinated or not. They still carried out criminal acts that fit within the definition of the common criminal purpose. We see that at paragraph 536 of their brief. This is reflective of the entire prosecution argument. The link between the perpetrators of crimes and the accused, that's immaterial. The accused is guilty by virtue of his position and guilty because he is a Serb. If we can have the next slide. On the first day of closing arguments, at transcript page 44387 through 44388, the prosecution played an audio recording of an intercepted conversation, P403, between Gagovic, Unkovic, and Mladić, where Mladić is asked whether some of Arkan's men were under VRS command. And Mladić replied, quote, all of them, all underarms are under my command if they want to stay alive. P403, page 3, and we have that under the screen. Now the prosecution wants you to believe that this excerpt means that Arkan's paramilitary group were under Mladić's command. But the context of this excerpt does not support that conclusion. If we read further, we see that Mladić is recorded as saying, so all should be under our command. No one should do anything on their own, and the 5-day truce must be observed. So the defense offers a second reasonable interpretation of the meaning of Mladić's statement. Mladić sent various orders calling for the disarmament of paramilitaries, demanding that all paramilitary members place themselves under the command of the VRS if they had not committed any crimes. For those who had committed crimes, they were to be disarmed, arrested, and prosecuted in the VRS military courts, P501, and those unwilling to join the VRS should leave the territory. So this statement can be interpreted as Mladić meaning that any armed Serb should be a part of the VRS, and if they are not, then they would be pursued and removed from the area. The prosecution has chosen one line and not presented this evidence in its entirety. We can move to the next slide. In further support of this interpretation, on 20 October 1995, the accused wrote a letter to Karadzic complaining about Arkan's men and criticized the civilian authorities' tolerance of him. This is D1503. Archon's Tigers were subordinated to the RS MOOP, and Archon was acting against the population and against the VRS. If we can go to the next slide. The prosecution claims that the overarching JC members, quote, redeployed notorious volunteers and paramilitary groups such as Shesho's Men, the White Eagles, and Archon's Tigers to BIH in 1992, end quote. And this is paragraph 577 of their brief. Yet Mladic's intent towards paramilitaries was clear. Paramilitaries were forbidden from operating in RS territory, and criminal charges would be instigated against them if they chose to do so. Again, P501. Despite the accused's attempt to incorporate former paramilitaries who were innocent men into the VRS, many of them refused. The standing orders of the VRS, which prescribed that paramilitaries should be disarmed or integrated into the VRS, remained unchanged throughout the war. Witness Chiracolo, transcript page 28489. Mladić did not support nor approve of their actions, nor did he exercise command or control over them. Once paramilitary groups were incorporated into the VRS, they were no longer heard of. For example, Bernays Chetniks were split up, with members being assigned to different brigades so as to prohibit them from regrouping once incorporated. Colonel Radojcic testified about that at 23054 through 5 of the transcript. Their leader, Bernay, was expelled from Bosnia. At paragraph 580 of its brief, the prosecution attempts to imply that paramilitaries were incorporated into the VRS and were allowed to commit crimes on behalf of the VRS, thus making the link of the criminal activities carried out by the paramilitaries to the accused. The prosecution also uses Mauser's Panthers, a paramilitary group that was incorporated into the VRS, to try and prove their theory that Mladić used paramilitaries to commit crimes in furtherance of the common criminal plan. The prosecution claims that Mauser's Panthers fought on the front lines, were eventually arrested for looting in July of 1992, and were never prosecuted, and instead incorporated into the IBK. Mauser's Panthers was an armed force set up by the Bielina municipality to defend the municipality. P3802, page 5, P1061, page 2. While it is true that the accused commended Mauser in 1993, this was not a reward for his criminal behavior. Witness Andan clarified that this commendation was awarded to the unit, not to the person. T22410 through 22411 and P6579. Whilst it is also true that Mauser and his unit were incorporated into the IBK, this was done at the local level, not by an order from Mladić. The prosecution has not provided any evidence to show that Mladić condoned of any criminal actions. There were no orders from Mladić to Mauser instructing him to commit crimes. A reasonable alternative explanation is that Mauser's Panthers were incorporated into the VRS in an attempt to control and instill discipline over them. The allegation that Mladić used them as a tool in furtherance of the common criminal plan has not been established beyond a reasonable doubt. The prosecution claimed that the paramilitary group called the Yellow Wasps were arrested not charged with murder, despite a statement admitting to the killings recorded by the military police. The witness used to support this, Dragomir Andan, explains on cross-examination that 11 paramilitary members were charged for criminal activities and the others were deported because they could not obtain evidence to prove they committed the crimes. Transcript page 22425. While Mladić attempted to curb the criminal behavior of paramilitary groups by incorporating them into the VRS and subjecting them to strict rules and regulations, he cannot be held accountable for those who refused to abide by these rules and acted out on their own. It is clear that these paramilitary groups acted for their own purposes and defied VRS command and control. Where possible, action was taken to prosecute them for their criminal acts. A main focus of the prosecution is the allegation that the accused exerted influence over the military justice system to protect Serbs who had committed crimes. Transcript page 44418 through 44419. We submit that at no time did the accused exert any kind of pressure on the military justice system. Indeed, the accused was personally supportive of the independent role of the military justice system. Witness RM 513, D 747, paragraph 8. The military judicial system was weakened by a number of factors which affected its ability to function. These included a lack of resources, experts, absconded indictees, absent jurors, and staff shortages. P 3560. It is important to remember that these courts were operating in challenging wartime conditions amidst the presence and prevalence of armed groups. The accused held a position of considerable authority in commanding the VRS, and there is no dispute that during that period, crimes were committed. As the defense has demonstrated convincingly throughout this trial, and summarized in our brief, in most cases, responsibility for those crimes rests with those outside the VRS, and in all cases, with those acting outside of the accused's effective control. If we can have the next slide. Whilst the prosecution was surprised that the defense referred to the accused's 16th Assembly speech, transcript page 44371 through 2, believing it was evidence of the common purpose, the defense argues otherwise. His speech, first as VRS main staff commander, was a call to act clearly and decisively, to be aware of the consequences of going to war and the importance of acting strategically. One of his first significant statements was, at P431, page 35, quote, "Therefore, we cannot cleanse, nor can we have a sieve to sift so that only Serbs would stay, or that the Serbs would fall through and the rest leave. Well, I do not know how Mr. Krajisnik and Mr. Karadzic would explain this to the world. People, that would be genocide. We have to call upon any man who has bowed his forehead to the ground to embrace these areas and the territory of the state we plan to make. He too has his place for us and next to us." End quote. Critically, this statement was made following Karadzic's presentation of the 6 strategic objectives, effectively challenging the Assembly not to interpret them as calls for unlawful violence against Bosnian Muslims or Bosnian Croats. Mladić expressed a wish to galvanize all people born in the Republika Srpska and warned that any war should be waged only in self-defense. We see that in P431, page 33 through 35. By the way, this interpretation is supported by prosecution military expert Ewan Brown at 19502 to 19503.
Mr. Ivetić, I'm looking at the clock. We're close to the point where we
I thought we were
take a break.
5
Yes,
minutes,
but it's
okay.
quarter past, but in order to make the last session 45 minutes
That's fine.
and the present one 55 minutes, that's... apart from that, before we take that break, on page 53, first line, you refer to paragraph 34 of the prosecution's final brief in the context of the position of the RS MUP in its the parallel civilian and military structures, so very much focusing on the RS MUP. Paragraph 34 seems to deal, however, with the subordination of paramilitaries in the VRS. So I wonder whether this may be a mistake, or perhaps I missed something relevant. Could you please check that?
Of course, Your Honor.
Then we'll take a break and we'll resume at 1:30 p.m.
All rise. Veuillez vous lever.